Pennsylvania takes an interesting approach to habitability law because the state doesn't have a single comprehensive landlord-tenant act that applies statewide. Instead, the rules depend heavily on where your property is located, and that's something every Pennsylvania landlord needs to understand. At the state level, Pennsylvania recognizes the implied warranty of habitability through case law. The landmark case is Pugh v. Holmes, decided by the Pennsylvania Supreme Court in 1979. This ruling established that every residential lease in Pennsylvania carries an implied warranty that the property will be fit for human habitation, and landlords cannot waive this obligation in the lease. Under this warranty, landlords must maintain the structural integrity of the property, provide functioning plumbing and sewage systems, ensure electrical systems are safe, provide adequate heating, keep the property free from serious health hazards, and comply with applicable building codes. Now here's where Pennsylvania gets complicated. The City of Philadelphia has its own detailed landlord-tenant code under Philadelphia Code Title IX, Chapter 9-1600. This goes well beyond the statewide common law standard and includes specific requirements for licensing, inspections, lead paint disclosure, and a detailed list of habitability standards. If you're a landlord in Philadelphia, you're essentially operating under a different rulebook than a landlord in rural Pennsylvania. Pittsburgh and other larger municipalities also have their own local housing codes and inspection requirements. So in Pennsylvania, local ordinances matter just as much as, and sometimes more than, state law. When it comes to tenant remedies, Pennsylvania allows rent withholding, but only under specific circumstances. The tenant must be current on rent, must have notified the landlord of the defect, must have allowed a reasonable time for repair, and the issue must be one that materially affects habitability. If those conditions are met, the tenant can pay rent into an escrow account rather than to the landlord. Pennsylvania tenants can also pursue claims for breach of the implied warranty in court, seek damages, and in severe cases argue constructive eviction to terminate the lease. One practical note: because Pennsylvania's framework varies so much by municipality, landlords who own properties in multiple cities or counties should familiarize themselves with each local code individually. What's compliant in one jurisdiction may not fly in another. For the full guide to Pennsylvania habitability laws, visit tenantscreeningbackgroundcheck.com and subscribe to our channel for every state in our series.